Okay, it is 1:30, and so we'll call the Board of Commissioners public hearing for February 7th, 2024 to order. This hearing is for file number 439-23-00008-LRP and file number 439-23-00024-SUB. And the purpose of the public hearing is to consider a Jackson County Planning Commission recommendation of approval for a minor zoning map amendment to rezone 3 parcels totaling 7.97 acres and a portion of the adjoining right-of-way, 0.63 acres, from White City Urban Residential 6, WCUR 6, to White City Urban Residential 8, WCUR-8, on property described as Township 36 South, Range 1 West, Section 16 DC, tax lots 800, 1200, and 1201, located north of Avenue E between Wilson Way and Timberline Road, White City. Bob Fellows Construction LLC, tax lot 800, and the Ray Edward Niffen Jr. and Deborah Jo Niffen Joint Revocable Trust, Living Trust, tax lots 1200 and 1201, are property owners, and again, file number 439-23-00008-LRP, and to consider a Jackson County Planning Commission recommendation of approval for a 38-lot subdivision application to create the new Falcon Landing on property described as Township 36 South, Range 1 West, Section 16 DC, tax lot 800, located north of Avenue E between Wilson Way and Timberline Road, White City. And Bob Fellows Construction LLC, property owner, and that is file number 439-23-00024-SUB, and nobody asked me to repeat that, please. We have planning staff Ted Zook and Don Ritterman, Director of Development Services and Planner 3, and our legal staff Pete Philbrick. And Pete, can you read the admonishments, please?
Thank you, Mr. Chair. Here are the rules for today's hearing. Please remember to direct your testimony and evidence toward the criteria or rules set forth in the published notice for this hearing. Those criteria, rules, and standards will be further outlined for you by staff momentarily. You may also direct your testimony to other criteria in the comprehensive plan, land development ordinance, or other land use regulations which you believe apply to the decision. Understand that a failure to raise an issue with statements or evidence sufficient to give the decision makers or other parties the ability to respond to the issue will preclude or prevent your appeal based on that issue. County is making a verbatim recording of the hearing. In the event of an appeal, it may be necessary to transcribe it. Therefore, when you testify or comment, please begin by clearly identifying yourself so that anybody reading a transcript of the record will know who is talking. We'll first hear from staff and the applicant will follow. Then we will hear from those who wish to comment in favor of the application, and then we will hear from those who are opposed. The applicant has the burden to prove the case, thus the applicant will have the opportunity to respond to the comments in opposition. Once everyone has had an opportunity to speak, the public hearing and the record will be closed unless there is a request for continuance. If so, then another set of rules apply. However, if there is no continuance, then the commissioners will proceed to deliberate toward a final land use decision. Finally, we have a couple of housekeeping issues to resolve. First, this is an opportunity for commissioners to announce whether they have had any ex parte contacts. If ex parte contacts have occurred, please discuss the nature and content of the ex parte contact or contacts so that the parties are aware of the substance of the communication when the hearing is open today and have an opportunity to rebut any evidence obtained via ex parte contact. Second, this is an opportunity for the commissioners to announce whether they have any actual or potential conflicts of interest with respect to the matter today or the applicant. If so, the commissioners may discuss the nature of that actual or potential conflict and address how they wish to proceed. Have any commissioners had any ex parte contacts or any actual or potential conflicts of interest?
I have none.
I have none.
And I have none.
Thank you, Mr. Chair.
Thank you. Okay, so we will request the planning staff report, please.
Good afternoon, Commissioners. Don Ritterman, Planner 3, Development Services, 10 South Oakdale, Room 100. The applicant is requesting a minor zoning map amendment to rezone 3 parcels with a portion of the adjoining right-of-way and concurrent 38-lot subdivision. Subject properties are located between Avenue E, Wilson Way, Falcon Street, and Timberline Road, shown in yellow on the map. Lot 36, 1 West, 16 DC, tax lot 800 is owned by Bob Fellows Construction, LLC. Lots 36, 1 West, 16 DC, 1200 and 1201 are owned by Ray Edward Niffen Jr. and Deborah Jo Niffen Joint Revocable Living Trust. The subject properties are all presently zoned WCUR 6, which allows for maximum density of 6 dwellings per acre. The proposal includes rezoning all 3 subject properties to White City Urban Residential 8, which allows a maximum density of up to 8 dwellings per acre. The proposed 38-lot subdivision will include 18 duplex lots and 20 single-family residential lots, 1 new public street, Alice May Way, and 1 internal private access road will be created. 2 existing streets, Go Way and Peregrine Way, will be extended. The revised zone change staff report provides findings that support the approval of a minor zoning map amendment from WCUR 6 to WCUR 8, and the revised subdivision staff report provides findings that support the approval of a 38-lot subdivision. The evidence submitted by the applicant supports the approval of the minor zoning map amendment and the proposed concurrent 38-lot subdivision. For this reason, the Planning Commission recommended approval unanimously. Are there any questions?
Questions? Nope. Thank you very much.
Okay.
Okay, and you did read the rules of the public hearing earlier, but next on the list.
The rules for this public hearing are established as follows. Only the chairperson or a member of the Board of County Commissioners may question a speaker. There will be no interruption of a speaker from the audience and no debates on the floor. Applause is not permitted. The speaker may criticize a proposal, the board, or an agency of the county, but the speaker shall not argue with any other speaker directly. Any speaker may present an opposite view, but not in personal terms. A person wishing to speak shall raise his or her hand and be recognized by the chair conducting the hearing. After being recognized, the speaker shall state his or her name and address before proceeding with his or her statement. The chair may limit the duration of any presentation to the time necessary to cover factual information. Repetition by the speaker shall be avoided. Mr. Chair.
Thank you very much. Okay, and with that, we will open the public hearing and accept hearing from the, or testimony from the applicant.
Good afternoon, Commissioners. For the record, my name is Jay Harlan with CSA Planning with offices at 4497 Brown Ridge here in Medford. We represent Bob Fellows Construction in the subject application. The record, I think, speaks for itself. Planning Commission did its normal thorough job, asked a lot of good questions. Staff presented, in detail to the Planning Commission, and I think provided a good summary here for the board, so I'm not going to belabor the details. I was chatting with Dawn briefly before the hearing, and I would like to speak to that a little bit. There's no plan amendment here, it's just a zone change, so I guess I was a little confused as to whether or not an ordinance is really required. Typically, an order is all you need for plan amendment and subdivision. Ultimately, I guess that form is, that's really a decision of county council, but what I would ask is if an ordinance really is required, if it's would be possible to do an emergency ordinance rather than a regular ordinance, because otherwise we got to wait 60 more days, essentially, before we can get public improvement plans issued to start the construction of the roads and implement the permit. So it's really just kind of a procedural thing, but I would request that if it does in fact require an ordinance, to allow it to be an emergency ordinance so that when the decision making is done, they can move forward. In this particular case of the project, there were some wetlands that took, 2 years to get the mitigation plan approved, and then the mitigation was through the mitigation bank, so the applicant has couple $100,000 they had to pay for the mitigation bank that's just sort of sitting there. So at some point here, they'd like to start building streets and selling lots. So if that's something that is workable in the county's procedure, we would appreciate it. Thank you.
Good night.
Happy to answer any questions about the project.
I'd like to ask staff, is there anything we need to consider granting an emergency ordinance that would cause some issues?
I would have to defer to Joel Benton on that, as they,
Right. Nothing, Ted, that you,
I'd just like to add, in speaking with Joel, since the application was concurrent and it came in at the same time, that's why it was brought to you with both applications. Personally, and then probably take Joel to give you the correct legal determination. I don't see an issue with what Mr. Harlan is asking, but I'd like to get that conferred with county council.
because normally this type of application wouldn't come to us.
No, normally you would only see the zone change.
Right.
And then later, the applicant would usually put in the application for the subdivision. What was different about this is it came to the planning commission concurrently, and both those items were there. So we brought them to you as both items to the board. But I think Mr. Harlan's request is reasonable, although I am not county council, so I don't want to speak.
Sure.
Yeah, I guess what I would say is if it's possible to do it that way, we would appreciate it. And if not, I guess that's, that's wait another 2 months, so.
No, I think we just want to make sure there's nothing we're not considering.
Sure.
I don't know if, and I don't want to extend this hearing, but is it possible to take a recess and talk to Joel?
I think Pete is working on that right now.
Oh, right now you're, okay.
Yeah, the other thing I was going to say about that is that that's really implementing the decision. So I think we could finish the hearing. You can make the land use decision, and this is really just the mechanics after the fact of exactly what is, how the decision's being implemented. And
Sure.
so if we don't, I hate to put Joel like on the spot that much, like in the minute, so.
No, you don't. Come on.
We like put him on spot.
It's what he's-
yeah, I'm going to try to
it's what he's
reach
here
out to him. I believe he has a dentist appointment, but
for. Okay. It's a dentist appointment. Well, let's,
Your hair gets fine.
yeah, he may not be capable of making a decision under the gas or something. Okay, at this point, we'll move along with the hearing then, waiting for Joel. It's obviously nobody here from the public to speak. Is there anybody online?
Mr. Chair, there is no one with their hand raised to speak.
Mr. Chair, can
Yes.
I chime in?
Yes, please.
I heard back from Joel. We can't do an emergency ordinance because they expire automatically after 180 days. So it's not a permanent solution.
Okay. I mean, that's, I got to take his counsel. All right, so we will close the public hearing. And
Be happy to make the next two motions if.
okay. Do we have any exhibits to?
Exhibits? What,
So for the LRP, we have 13.
Okay.
And then separately for the SUB, we have 12.
okay. Okay, so I move to admit exhibits 1 through 13 into the Board of Commissioners record for file number 439-23-00008-LRP and to close the record. I further move to admit exhibits 1 through 12 into the Board of Commissioners record for file number 439-23-00024-SUB and to close the record.
Can I second both of those motions? Can they be made together?
Oh, I made two motions. You're right. Should have waited. I should have paused.
Yes.
Sorry.
Second. Let me do it again. Make the first and I'll second it.
Okay.
Or
So
slow
I'll-
it.
Withdraw the first
Exhibit.
motion.
First motion is still good, right?
I wasn't even on the
I think you made
microphone.
them together. I would say withdraw them and then just restart from the beginning.
Okay, all right. I I will withdraw those two motions. I move to admit Exhibits 1 through 13 into the Board of Commissioners record for file number 439-23-00008 LRP and to close the record.
I'll second that.
Commissioner Daughter,
Yes.
Commissioner Roberts,
Yes.
Commissioner Dyer,
Yes.
Okay. And I move to admit Exhibits 1 through 12 into the Board of Commissioners record for file number 439-23-00024-SUB and to close the record.
I'll second.
Commissioner Daughter,
Yes.
Commissioner Roberts,
Yes.
Commissioner Dyer.
Yes, thank you. Well, we can deliberate now. We'll wait and see what, I guess there's nothing, no new information. All right, well, again, deliberation on this?
Well, it's a shame we can't move with the emergency, but I'll make a motion. We can deliberate after that. Based on the evidence and testimony, I move to approve the application for a minor zoning map amendment to rezone 3 parcels totaling 7.97 acres and a portion of the adjoining right-of-way, 0.63 acres, from White City Urban Residential 6, WCUR 6, to White City Urban Residential 8, WCUR 8, on property described as Township 36 South, Range 1 West, Section 16 DC, tax lots 800, 1200, and 1201, located north of Avenue E between Wilson Way and Timberline Road, White City. Bob Fellows Construction LLC, tax lot 800, and the Ray Edward Niffen Jr. and Deborah Jo Niffen Joint Revocable Living Trust, tax lots 1200 and 1201. Property owners, file number 439-23-00008 LRP, and to approve a 38-lot subdivision application to create the new Falcon Landing on property described as Township 36 South, Range 1 West, Section 16 DC, tax lot 800, located north of Avenue E between Wilson Way and Timberline Road, White City. Bob Fellows Construction LLC, property owner, file number 439-23-00024-SUB.
Second.
Okay, now deliberation.
Now we can deliberate. Yeah, there was no objection here, nor I think in the Planning Commission meeting as well. And it's great to see homes get built.
No, I think this is a great project, so, yes.
Certainly,
Yep.
greater density
Don't need
allows
to
for,
deliberate a long time.
greater density will allow for more homes, and we definitely need more affordable homes, and it looks like most of the properties surrounding these properties are either WCUR 10 or 8, is what it appears, so it's
More
definitely
to come.
appropriate in the neighborhood.
Yeah.
All right, we'll take a vote.
Commissioner Roberts,
Yes.
Commissioner Daughter,
Yes.
Commissioner Dyer.
Yes. Okay, so I would ask staff to prepare one ordinance of approval with conditions for both files and set dates for first reading and second reading public hearing of ordinance. First reading being March 13th, 2024 at 9:30 a.m., I imagine here in the courthouse auditorium. And the second reading and public hearing to be held in the courthouse auditorium and by audio-video conference on March 27th, 2023 at 1:30 p.m.
2024.
Oh, it is, well, this says 2023, but you're right. That would be hard to do. March 27th, 2024 at 1:30 p.m. And with that, this meeting is adjourned.
Yeah, Colleen, I was just making sure you were awake. I just kept reading. Let me get this over. Come on.